In March of 2020, the Office of the Australian Information Commissioner, the OAIC, launched proceedings against Facebook Incorporated into the Federal Court of Australia. The OAIC alleged serious and repeated contraventions of the Privacy Act. Today, we will be looking over the ongoing case. I'm sure we've all taken an online survey at one point. Whether it's a light-hearted BuzzFeed quiz that tells you what flavour ice cream you are, or an in-depth personality survey that tells you whether you're an introvert or an extrovert. Surveys and quizzes are everywhere, particularly in the digital world. I took this BuzzFeed survey the other day where I had to build a sushi roll and BuzzFeed would tell me what character from The Office best matched my personality. Results came in and apparently my sushi order matches Michael Scott's personality, which I'm not too sure how to feel about. You may have even taken a quiz you've seen on Facebook, or maybe have even had to log in through Facebook to access this survey or quiz. Well, this is exactly what 300,000 Facebook users did. First, let's understand what actually happened and why there was a data privacy breach. A UK-based academic, Alexander Kogan, used Facebook data for research purposes and created a digital app called This Is Your Digital Life. This digital app featured a personality quiz, which gave over 100 traits to agree or disagree with. The only catch with users taking this quiz was that they had to log into Facebook, which gave Kogan access to your profile, which included your birthday, location, Facebook likes, and most importantly, your Facebook friends. Kogan combined these quiz results and Facebook data to form a psychometric model, which is some form of a statistical personality profile. The app also gathered the data of your Facebook friends and compiled similar personality profiles. Over 270,000 Facebook users downloaded this app and took this survey, resulting in data of up to 87 million Facebook users harvested. Kogan went one step further and combined this data with voting records and sold this information to an analysis firm called Cambridge Analytica. Cambridge Analytica is a data mining and political strategy firm that worked on Donald Trump's 2016 presidential campaign. Cambridge Analytica improperly obtained access and used this data for political advertising targeting purposes. The big issue with this was that there was no disclosure to users that their data was going to be collected and sent to a third party, and users did not consent to information sharing. This data was then used by Cambridge Analytica to build powerful software that could predict and shape voter choices. The OAIC's move against Facebook follows action already taken by its international counterparts. Facebook was fined £500,000 by the UK data protection regulator for their breach of privacy laws in the UK and received a fine of $5 billion following an investigation held by the US Federal Trade Commission. This was a global privacy breach. However, we'll be focusing on the privacy breach within Australia and the action of the OAIC against Facebook. In March 2020, the OAIC brought action against Facebook, its US and Ireland-based entities, in the federal court, alleging serious and repeated contraventions of the Privacy Act. Just to recap, the Office of the Australian Information Commissioner, the OAIC, is an independent statutory agency established to promote and uphold privacy and information access rights. It has a range of regulatory responsibilities and powers under the Privacy Act, Freedoms of Information Act, and Australian Information Commissioner Act. It's important to note that this claim marks the first attempt in Australia to seek civil penalties through the federal court for contraventions of the Privacy Act. Australian Facebook users whose data was shared only accounted for 0.4% of users affected by the global data breach. The OAIC found that although 53 people in Australia actually installed the app, the data of over 300,000 Australians was collected and shared with Cambridge Analytica. This demonstrates the reach of the app and the extent of the privacy breach, as this not only collected the data of people who installed it, but also their friends in their Facebook network. Now that we've covered the facts of the case, let's look at the law and what elements of the Privacy Act that the OAIC claimed Facebook breached in Australia. The OAIC argues that Facebook's conduct amounts to serious and/or repeated contraventions of the Australian Facebook users' privacy, specifically Section 13G of the Privacy Act. Furthermore, the Privacy Act includes 13 legally binding privacy principles, or APPs, which apply to agencies and organisations covered by the Privacy Act, APP entities. These privacy principles govern the collection, use and disclosure of personal information by businesses and agencies operating in Australia. The OAIC claimed that Facebook breached APP 6 by disclosing the user's personal information for a purpose other than what it was collected for. APP 6 provides that if an APP entity holds personal information about an individual that was collected for a particular purpose, the entity must not use or disclose the information for another purpose, unless the individual has consented to this use or disclosure. Facebook collected users' personal information for the purpose of enabling those individuals to build a social network with other users on that platform. Facebook contravened APP 6 as the disclosure of personal information of users to the This Is Your Digital Life app was not used for that same purpose. The Commissioner also alleges that Facebook is in breach of APP 11 by failing to take reasonable steps to protect the user's personal information from unauthorised disclosure. APP 11 outlines that an APP entity must take reasonable steps to protect personal information it holds from misuse, interference and loss, as well as unauthorised access, modification or disclosure. The Commissioner has alleged that Facebook failed to take reasonable steps to protect the individual's personal information from unauthorised disclosure, and further claims that Facebook was unaware of the precise nature or extent of the personal information that was disclosed to Kogan or the app. To avoid liability, US and Ireland-based Facebook appealed to the federal court and argued that they were not subject to Australian privacy laws, as they did not conduct business in Australia. They argued this because the data was not processed by an Australian registered company, but instead processed by Facebook Ireland and in data centres located in the US. You may be thinking, why can't the OAIC just launch proceedings against Facebook Australia instead of going through this hassle to prosecute US and Ireland? Well, Facebook's office in Australia is limited to particular aspects of its business. It's incorporated in the US and Ireland. The OAIC must proceed against Facebook's corporate entities. So what was the decision? The most recent update on this ongoing case was on the 7th of February 2022. The federal court dismissed Facebook's argument and found them to be carrying on business in Australia through enabling cookies on Australian users' devices. The use of cookies is an important part of Facebook's operations. Facebook is therefore bound by Australian privacy laws, and the OAIC is entitled to proceed with their case. So what does this ruling mean? Well, the case is not over, and the OAIC can pursue action against Facebook for serious and repeated contraventions of the Privacy Act. The federal court's ruling earlier this year that Facebook was carrying on business in Australia is an important wake-up call for overseas-based online businesses, as it sets out the requirement for an Australian link, making foreign corporations who carry on a business and collect or hold personal information in Australia subject to the Privacy Act. Overseas-based online businesses that rely on common technologies such as cookies and APIs should review their compliance with Australian privacy law. Thank you.